Welcome, everyone. I'm Margarita Amaxopoulou. I am a researcher at Queen Mary University of London. Welcome in this webinar. We today are very glad to have with us Valentina Torelli, who is an IT data protection lawyer and certified DPO based in Milan, and Desislava Efesenko, who is an antitrust and technology lawyer and AI ethics and governance researcher. So today we are going to talk about AI regulation in Europe, and this presentation takes a comparative look at the difference of the approaches between the UK and the EU. Of course, there are. I believe there is no need for me to invent a persuasive strategy for you all to kind of stress how important this issue is. We all have seen the latest regulatory developments around the world. We have the US blueprint of rights. We don't know how this is going to unfold. We have China, who is introducing its new AI rules, and more particularly lately their generative AI specific rules. We have the latest developments on the EU's front with with the parliament's votes coming in the middle of this month, and then the intense trialogue that is going to follow. And we also have the UK's approach to AI regulation. So it really is very meaningful to take a step back and actually try to see how the different approaches kind of stand side by side. And indeed, the EU is going to, the EU regulation, the EU AI regulation is going to be here and is going to be influential transnationally in the years to come. And the UK now, after Brexit, indeed wants to, at least what we see currently is that it wants to put clear water between itself and the EU. However, I'm not so sure about the extent of this divergence. So please, a warm welcome to our speakers. And you will be also able to, in this very first part of the presentation, to hear a bit more about who we are and what is the distance learning chapter. The floor is yours.
Thank you very much, Margarita, for your nice introduction and the description of the purpose of this webinar. Welcome everybody to this first event delivered by the Distance Learning Alumni TMT chapter, whose organization, of course, could not have been possible without the contribution of my former course mate, Desislava. We met while attending the LLM in Computer and Communications Law a few years ago. As promised, we would like to say a few words on the CCLS Distance Learning Alumni TMT chapter, which is a group of former students of the CCLS Distance Learning TMT postgraduate courses who collaborate with the CCLS alumni team to promote initiatives such as this webinar and to help students to keep in touch, share knowledge and experiences in the field of technology, media, and telecommunications law, and incentivize networking. You can interact with the TMT chapter and the alumni team by reaching out by email or LinkedIn and participating to this event. And indeed, we would like to invite you to engage with us, with the distance learning TMT community, by proposing new subject matters for future webinars and volunteering as speakers or inviting other speakers in one of those. And if you are current students or former students of the postgraduate courses, you can also join the CCLS LinkedIn group pages. For any information, you can drop an email to Catherine Bennett, who will be in touch shortly with you. But without further ado, let's get to the agenda of today and see what we are going to talk about. Of course, we will focus on the risk areas and the ethical concerns revolving on the development and use of AI. Then we will look at the regulatory roadmaps of the two initiatives in the EU and the UK, respectively the AI Act and the white paper on AI. Then we will describe the regulatory approaches that the EU and the UK have decided to adopt in regulating AI, making reference to the AI definition and the AI categories where applicable. And then we will briefly touch on the obligations that stem from the development and adoption of AI technologies, mentioning aspects such as sandboxes, technical standards, and how regulatory powers are attributed in the two jurisdictions. That said, I'm pleased to leave the floor to Desislava, who will talk about the main risk areas and ethical concerns about AI.
Good afternoon and good evening, everyone. Thank you, Valentina, and thank you to both of you, Valentina and Margherita, for the opportunity to be joining the CCLS chapter webinar today and to be speaking about ethics and governance of AI in the EU. It is a great pleasure, and I look forward to the discussion afterwards with all the participants. Please feel free to drop your questions in the course of the webinar in the chat box, and we'll be addressing them afterwards. I would like to set the scene for our headline topic today and the broader discussion by dwelling on the main risks and ethical concerns pertaining to AI. And the reason for this introduction is in a way benign, but I think also important. Those risks and ethical concerns essentially lie at the heart of the AI regulation in Europe, and to a large extent shape the thinking of the legislator in the EU, and also the approach and the toolkit the legislator is setting up for regulating AI in the EU. But before doing that, I guess we need to just naturally say a few words about what is AI, or try to set a baseline from which we'll be discussing this scientific advancement and to a large extent social phenomenon as well. And any definition would naturally reference a definition of human intelligence. But as I guess most of you know, psychology, neuroscience, philosophy, and philosophy of mind in particular, and other social sciences are still in the process of defining, researching, measuring the various dimensions of human intelligence, and to offer such a settled conception of intelligence. So the best thing I could, for the purposes of our talk, could think of is essentially offer the definition that Stuart Russell and Peter Novick in their authoritative textbook Artificial Intelligence come up with, a very generic but still sets up, I think, useful scientific baseline. And it is that AI is essentially a type of technology through which machines can compute how to act effectively and safely in a wide range of situations. And I think it, in a way, suggests what is the gist of the technology, the idea that a machine, essentially a computer, computes with the help of software or a complex system of softwares, possible courses of actions or output by employing algorithms, mathematical formulas, drawing on data and statistical representations of events in the real world, and trying to suggest possible output, courses of action, predictions, way forward for the users. In the history of the technology, various computational methods have been tried, applied, developed throughout time. And it is useful to mention them just for the sake of our discussion going forward and for understanding better the legal definition of AI. And those are the methods set out on the slide: knowledge-based, logic-based methods, or machine learning. I guess most of you relate more to the machine learning method as what AI represents in nowadays, and indeed is a prevalent one. But AI is more than machine learning and deep learning and neural networks. A large amount of AI systems out there in the real world are actually logic or knowledge-based as well. Different models exist, and what is and in what AI is specifically successful are the narrow system models. That means a system, a software, an AI system trying to address, resolve a very specific narrow task, or another variation of a system model are the so-called foundational models. GPT is a good example, or DALL-E, or the other possible large language models that big tech comes up are typically examples for such foundational models. They try to resolve a variety of issues and tasks based on their larger computational models processing huge amounts of labeled data in a supervised way. AI has a long history. We wouldn't be talking about this right now, of invention, reinvention, AI winters, and then springs and summers. This is important just for us all to keep in mind that AI has been around for a long time, and this has given scholars and researchers the opportunity to think about it, and for legislators to at a certain point understand the need of regulating the technology as well. Next slide, please. And since AI has been around for essentially 10 to 15 years, since the late 2000s, in various shapes and forms, scholars and researchers have had the chance to actually examine it closely and to understand where risks stem from, what are the deficiencies of the technology. And a number of research teams, some of them listed here in the footnote as sources, have come up with a taxonomy of possible risks. And all of the majority of the researchers kind of agree on a broader set of 6 groups of issues or risks that come up most often in the work of AI systems more generally. I'll just briefly guide you through so you understand what are the risks, what are the ethical concerns associated with them, and how they actually prompted regulation of the technology at a certain point. So when we are speaking about discrimination, exclusion, and toxicity, what is meant here is that AI is trained on data, on sometimes large amount of data, and if this data is unrepresentative or underrepresentative, contains social biases or somehow is inaccurate, insufficient, AI naturally perpetuates stereotypes or misconceptions about the real world. And this may result actually in perpetuating social bias, stereotypes, and discrimination. When the training data contained toxic language, like language of hatred or violence, then the output of an AI system could also contain those elements or characteristics. Information hazards or information hazard as a category is associated with the presence of personal data in the data sets. Some AI systems, those that are more complex and compute and process more data, essentially are sometimes able to link different data points and to infer from them details about persons, for example, their demographics or social status. So information hazard arises when an AI system is able to do that without the knowledge or consent of the data subjects, and in this way the system encroaches upon their privacy. Misinformation harms boil down to the propensity of AI systems to churn out false or misleading output. And This is unfortunately the case because AI is in its essence compute, mathematical models, and a lot of data. The systems are not able to distinguish right from wrong, false from true, incomplete from complete pieces of information. It essentially offers an output that is more likely statistically based on its almost mathematical and statistical model and training data. And it is possible to offer as output incorrect or incomplete information, which results in misinformation hazard. This is potentially concerning because this kind of information may be misleading human beings taking decisions based on the output of AI systems. Malicious uses may arise when an AI system is hacked or hijacked and used in intentionally malicious ways in order to harm or, for example, start or propagate cyber security attacks or misinformation campaign or political propaganda on the social networks. And those are essentially concerns about safety and security and how the system interacts with the world and what kind of general environment it creates, both media-wise, but also in the context of humans gleaning, deciding based on the information outputted from AI systems. Human-computer interaction harms relate to actually the human propensity to trust or to be willing to trust something that resembles a human being or sounds like a human being. Those concerns date back from the 1960s when Joseph Weizenbaum at MIT created the chatbot Eliza, and his secretary started conversing with this chatbot as with a human being. So it is a natural human feature for us to relate in this possible way. But I think we see these kind of reactions also now when people converse or chat with ChatGPT in a very human-like way. So concerns here are that these create an artificial type of relationship between the system and the human, which may create grounds and conditions for manipulation, intended or unintended manipulation, and possibly also malicious use. And automation, access, and environmental harms essentially group three kind of harms concerned with the way AI systems work more generally. The fact that they, especially large scale systems, use a lot of compute, which means use a lot of energy, which means having huge carbon footprint. The broader deployment of AI in general, the business case there is that a lot of processes in the real world could actually be automated, be it in production business or services sectors, which means a lot of people doing this kind of job now would potentially either lose their jobs or their function would be scaled down. And this may lead to some form of job displacement for both blue and white workers. And another concern in terms of access is whether certain groups of the population, especially socially marginalized groups, would actually have the possibility to use those technologies if, for example, they don't have access to internet or to a contemporary mobile device like the latest version of a smartphone. Next slide, please. So what are the ethical concerns in relation to AI? I think we've just briefly touched upon most of them, but I've tried to summarize them here. The concerns are essentially that what the technology represents and how it functions may result in either some loss of personal autonomy and agency for human beings, or their unequal access to opportunities, due to unfair treatment or discrimination. The use of the technology may harm some of them materially or immaterially if people don't get access to education, healthcare, jobs. That the technology naturally entails the propensity to encroach upon personal privacy due to its ability to influence personal characteristics of users. The technology may actually have a tangible impact on deliberative democracy more generally. I think we've seen that in a way in election situations in the UK and the US, Cambridge Analytica and Brexit, those kind of situations. Social inequality has to do with the idea that if the technology is widely deployed, there would naturally be winners and losers. And unless people that are losing their jobs or people that are not having proper access to this technology somehow made better off, that would be on the losing end. And environmental harm has to do with the significant energy consumption and carbon footprint that the technology has nowadays under its ecology of use of energy and natural resources. Next slide, please.
Well, we have seen what the risk and the ethical concerns may arise from the development and use of AI, as Desislava kindly explained. And if we look at the regulatory roadmap of the EU initiative on regulating AI, an important point of time is certainly given by the publication of the white paper on AI on the part of the Commission, in which it provided a policy option for the future EU regulatory framework based on a risk-based approach and the identification of high-risk AI applications, along with the types of legal requirements, obligations following that type of high risk. After the publication of the white paper, the EU Parliament adopted a number of resolutions providing recommendation on AI in the field of ethics, copyright, and liability, and urging the Commission to publish a regulation, and this occurred in April 2021 with the publication of the proposal for the AI Act, and with which the Commission started the ordinary legislative procedure for the adoption of a regulation, which is a binding legal act of secondary law based on the Treaty on the Functioning of the European Union, which will be applicable throughout the European Union. It is worth mentioning that a few months later, in June 2021, the European Data Protection Board and the European Data Protection Supervisor issued a joint opinion on the proposal for the AI Act, and they welcomed the risk-based approach of the Commission in the proposal for the AI Act, and stressed the necessity that the requirements for GDPR compliance and for the compliance with the Regulation 2018/1725 be comprehended among the requirements for the high-risk AI systems. Why I mentioned the Regulation 2018/1725? Because the proposal for the AI Act will also extend to EU institutions, bodies, and agencies. That said, in parallel, the other two co-legislators, the Parliament and the Council, carry out their discussions and their analysis of the proposal brought forward by the Commission, and amended the text of the AI Act. In December 2022, that means 6 months ago, the Council published its general approach with its proposal for amendments, and almost 1 month ago, on the 16th of May, in a joint committee procedure, the parliament, the two committees which are in charge of the amendments to the proposal for the AI Act made public the draft compromise amendment, which will have to be voted by the whole parliament in the plenary session in a couple of weeks. We should expect that vote for the adoption of the general approach in mid-June. After that, we can expect that the trilogue negotiations, which is the convergence of the Commission, the Parliament, and the Council, occurs in July and will continue at least until the end of this year in order to agree on a compromise text, which will be finally adopted. The final adoption might occur in the first quarter of next year, and then the AI Act as a regulation will become applicable at least 24 months after the entry into force, and we may expect that applicability in the first half of 2026. Now, if we move on and look at the regulatory map for the UK white paper, we can trace the most relevant event in this regulatory map in July 2022, when the Office for the Artificial Intelligence, which is an expert team created within the UK government, published a policy paper that is called Establishing a Pro-Innovation Approach to Regulating AI, which contains the proposal for the regulatory framework on AI in the UK, and which is underpinned by a set of cross-sectoral principles that will be issued by the government and provided to the regulators, which will be expected to interpret those principles and to apply them within their remit, so in their specific sectors and context. A call for views was open according to this policy paper in order to collect feedback from the AI ecosystem, and those feedbacks were used to draft the white paper which we are discussing today in this webinar. And basically, the white paper concern the identification, interpretation of those principles, and rules on the cooperation between the government, the regulators, and an additional layer of supervisory powers, which is informed by the central functions newly to be established by the government, which will be delegated with tasks in the governance of the regulatory framework. It is important to mention that even according to this UK roadmap, the ICO, which is the Data Protection Supervisory Authority in the UK, rendered its opinion on the white paper. And in this case too, the ICO stressed the importance that the interpretation of these cross-cutting principles on AI be in line with the data protection law applicable in the UK, besides asking clarifications on the roles that the regulators will have along with the government in providing guidance to the businesses which will have to apply the principles when developing and using AI systems. Now we can dig into the regulatory approach of the EU under the AI Act, and Desislava will talk about that.
Thank you, Valentina. So you can see that it has already been 5 years now of intensive work in the EU on an AI regulation, and we'll probably be seeing it adopted later this year. And it will be 2 further years before it actually becomes effective. And while the specifics of the AI regulation are still being kind of ironed out and it will be negotiated between the European Parliament, the Council of the European Union, and possibly the European Commission, I think we can kind of already settle now what the main basic features of the EU AI Act will be. And I would just broadly group them in four main categories or main pillars that would underpin the EU AI Act going forward. I don't think this would actually change. We will touch upon each one of them in turn in the next couple of slides. Next slide, please. So the first main pillar is that the EU Act will be resting on a framework of ethical principles that actually form the key tenets of the EU AI Act. Valentina just briefly mentioned that the regulatory process in the EU essentially started from the work of a high-level working group on AI, on a trustworthy AI, essentially a group of more than 50 experts in various fields of science and social sciences and business that the European Commission tasked in 2018 to work on a framework how AI could be ethically and safely deployed and used in the EU. And this high-level working group came up with guidelines on ethical use of AI. And these guidelines is essentially pillared based on 6 core principles, which the diagram on the left-hand side summarizes here. And these principles weren't originally included in the European Commission's proposal for the AI Act, but they just recently re-emerged in the European Parliament draft position here on the right-hand side. And you can see how ethical principles proposed by the high-level working group directly translate into legal principles to be introduced as legal norms, possibly when the EU AI Act is adopted later this year. Those are 6 fundamental principles that actually have very strong ethical connotations, and that would be informing and shaping both outcomes and expected levels of compliance, but also would be informing regulatory intervention and enforcement of the EU AI Act going forward. They're so broad and overarching, I'm sure that would be subject to various and probably disparate interpretations going forward. And those of you who love ethics and philosophy may be actually doing yourselves a favor to dust off your ethics textbooks and revisit basic tenets as fairness and well-being, because I think a lot would essentially hinge on them going forward. Next slide, please. Another key element of the regulatory approach of the EU AI Act is that the level of intervention essentially reverts around the level of risk that a system poses to its users and also to social life more broadly. We use various types of algorithms and narrow AI systems in our daily life. Just the mere fact of you unlocking your smartphone means engaging with such a narrow AI system, facial recognition. Not all AI systems in use would be essentially regulated under the EU AI Act. And the key premise here is that not all of them pose tangible risk to users and the wider public going forward. So the EU AI Act kicks in with respect to certain kind of systems beyond a certain level of risk, significant or moderate risk. And Valentina will be speaking about the type of, first of all, the legal definition of AI that the AI Act adopts now and what are the various risk classifications going forward. But just to set the scene here, I would like to just distinguish 2 broader group of risks that the EU AI Act attempts to tackle going forward. The first one is when AI systems are a safety component in physical products like toys, machinery, medical devices. then the concern there is that an AI system is so fundamental to the health and safety of its users that it needs to meet certain standards and be up to certain level of safety. So those kind of systems will be regulated by the EU AI Act and also the specific sector regulation that tackles the specific area of life or business. And here on the bottom of the slide, I've jotted down a couple of examples of what those AI systems are. The second broader category of AI systems under regulation under the EU AI Act would be standalone AI systems that somehow impact the exercise of personal fundamental human rights, the rule of law, access to opportunities more broadly, or the environment, and the democratic process. And examples to that effect are also noted down at the bottom of the slide. And this is probably the more tangible and broader category of risks that we, I think, all facing in our daily life around access to educational employment when AI systems are deployed for pre-screening of candidates, or when they're used for predictive policing, or as it was in the past in the case in the US for in the judicial system for determining the amount of bail and so on. Next slide, please. Another element, key feature of the EU AI Act is essentially that it is not extremely prescriptive in terms of substantive requirements beyond the principles that we spoke about. It is not like the well, it is in a way like the GDPR, but in a very different way. It doesn't pinpoint specific substantive requirements that an AI system needs to meet, specific KPIs at the level of the regulation. This will probably come later on in standards. What the EU AI Act provides for are specific effect-oriented process-based guardrails, what AI developers and users need to go through as processes in order to ensure that their AI systems are safe, secure, trustworthy more generally. And these guardrails can be grouped in 4 categories that correspond to specific type of conditions and obligations that the system needs to meet. I've noted it down here on the slide, and they relate to the processes around risk management, transparency and disclosure, quality management, and regulatory oversight going forward. And we'll say a couple of words about them as well. Next slide, please. And last but not least, AI Act is a horizontal and complementary in its regulatory approach. It is horizontal in the sense that it's a horizontal regulation. That means that it applies across the boards to various sectors that deploy AI. It is complementary in the sense that it regulates and governs specifically the design, development, deployment, and use of AI systems in its scope. But in addition to that, apply also a myriad of other regulations that actually has something to do with how the AI supply chain works. And those are data protection regulations, data governance, the Data Act, the Data Governance Act, cybersecurity regulations, in particular, the Cyber Resilience Act would play a huge role. Platform regulations like the DMA and DSA, antitrust regulations, consumer protection regulations at EU level and at national level. So it is that AI wouldn't be regulated only by the EU AI Act. There would be other type of legal instruments kicking in and playing a role. Next slide, please.
Thank you. This is Lava. And well, you displayed huge overview of the regulatory approach in the EU. And one main difference of the UK approach under the white paper from the EU approach is that the UK government has brought forward no legislative process to adopt a legislative act for regulating the AI. The UK approach in the white paper is based on a context-specific approach because rules and risk levels are not assigned to sectors or technologies. No categories such as AI, high-risk AI systems are present in the proposal of the UK government, and the regulation is based on the outcome that AI systems are likely to generate when applied in a specific context. In addition, the UK approach is underpinned by principles, so it's principle-based, more or less in the same vein as the principle approach described by Desislava before, according to the high-level expert group and the ethics guidelines. And those principles have been chosen by the UK government and according to the principles already developed by the Organization for Economic Cooperation and Development, the OECD, because the white paper has also the purpose of being capable to exchange its approach with other approaches worldwide and to be interoperable with other jurisdiction choices with regard to the regulation on AI. And this is a very sensitive topic, in my opinion, if we look at the extraterritorial effects that the AI Act as a regulation might have if some provisions that have been proposed will be definitely approved. And those are principles which are underpinning the UK approach would lead to have AI systems designed, developed, and used in a way that they can function robustly, securely, and safely, with, of course, appropriately and clearly transparent and explainable reasons. And a system would be also or should be also fair. That means that they cannot and would not undermine the legal rights of individuals, but also companies, and would not discriminate unfairly against individuals or create unfair market conditions. And the actors involved in the AI supply chain would have to put in place governance measures in order to ensure the oversight of the systems throughout the life cycle, as well as clearer accountability task to ensure risk assessment and the mitigation and management of risk. Finally, there's a principle, the principle of contestability and redress, which would allow the actors involved in the AI value chain to contest and ask for redress in case of decisions or outcomes which are harmful or may create a material risk of harm. As Desislava was anticipating, the definition of AI is a very important topic, both in the EU AI Act and in the white paper. Briefly, as regards the EU AI Act, the definition has been changed according to different line of reasoning by the Commission, the Council, and the Parliament. What the Commission at the beginning proposed was to define the AI as a software that for a given set of human-defined objectives can generate outputs such as content, recommendations, predictions, and decisions that influence the environment and interaction of the system. And to complement that definition, with the list of techniques and approaches that are usually used to develop AI systems, which are the approaches that Desislava mentioned before: machine learning, knowledge and logic-based approaches, and statistical approaches. And the Council decided to narrow down the definition and try to make it more adherent to the characteristics of the AI systems, that are autonomy and adaptability, in the sense that the system may usually take decisions without or behind the intent, the control of human actors, and are usually trained to operate by inference and have the ability to learn how to infer differently and how to find new correlations and new connections among the data when they are trained on a huge set of data. And finally, the Parliament was proposed to bring forward the definition of AI already adopted by the OECD, which I mentioned before. And this is another similarity in terms of approach to the regulation of AI, because also the EU AI Act is open to the interoperability with other jurisdictions' regulatory frameworks. That said, the definitions included in the AI Act also encompass all the actors participating to the AI value chain, and many other concepts which are important to define a sound regulatory framework, such as the definition for affected person, which seems to be referring, at least according to my interpretation, only to individuals, natural persons so far, and also definitions such as risk or significant risk. We also need to mention that the Council specifically introduced a definition of general purpose AI, and this decision was backed up by the EU Parliament, which also added the definition of foundation models. If we look at the choice of regulating AI according to the white paper of the UK government and the definitions provided in the white paper, simplicity is in order, because AI is defined as products or services that are adaptable and autonomous. It left to be seen how the single regulators will interpret those two characteristics of adaptivity and autonomy within the remit, and how they will deliver context-specific definitions of AI. And this is an area of monitoring and evaluation on the part of the government, because it will be necessary to then centrally oversight the application of those principles and definitions. Also, the white paper includes other definitions. In this case, definitions on the actors involved in the AI supply chain, such as the AI supplier, the AI user, and the definition of impacted third party, which specifically include not only individuals but also companies. Then, as Desislava was anticipating, we can consider under the EU AI Act the categorization of AI according to groups, depending on the varying level of risk that has been assigned to those systems falling within each group, in view of a risk assessment predetermined by the Commission and by the legislators, the co-legislators, the Council and the Parliament. So against the fact that we have prohibited practices that pose an unacceptable risk for the fundamental rights, the safety and the health of individuals, then we will have higher risk AI system, which will trigger specific requirements and obligations on the part of the different actors involved in the AI supply chain. Then in the original proposal of the AI Act, according to the Commission, the following category would have been the low risk AI, for which only transparency obligation in terms of informing individuals would apply, informing individuals of the fact that they were interacting with AI system should have applied, and at the bottom of the pyramid, there would have been minimal risk AI, free to use, but the Council and the Parliament, as I said, focus their attention on the general purpose AI and on foundation models, which per se are not classified as high risk AI, but depending on the intended purpose that they have, and therefore how they can be possibly used, they may become a high risk AI system. Also because some of the requirements for AI, high risk AI system will apply to them. According to the white paper, in the UK, there are no AI categories except for the fact that the UK government found it necessary to take a closer look to foundation models and to define them as models that are trained on a vast quantity of data and are adaptable for use on a wide range of tasks. And we didn't stop and retain on the definition of foundation models according to the EU AI Act, but the wording is almost identical. So there's another convergence of the two approaches in this regard too, which is very important given the possibility of this foundation model to be generative and to be also opaque as regards the way that they arrive to certain decision and outputs, and on the fact that they have some limitations because they are not trained on a sense of truth, and sometimes they have the so-called hallucinations because they provide outputs that seem real, but and accurate and true, but indeed they are false and mistaken. Now we can, yeah, someone has spoken. No, so now
there is can someone in the audience must be we can hear someone, so please make sure that you have your microphone on mute. Thank you.
So now we can talk about the obligations according to the EU AI Act, and Slava, can we go on that?
Yes, thank you. I can see that time is advancing, and we would probably like to leave out enough time for Q&A later on. So I would just briefly touch upon more broadly the categories of obligations under the EU AI Act. This naturally flows from the idea what kind of effect-driven outcomes the AI Act is targeting, as we just discussed a couple of slides ago, and that essentially the AI Act is making sure that there are processes in place, there are process-based guardrails in place. So building upon this philosophy, the Act introduces 8 main kind of obligations with respect most notably to high-risk AI systems, but one of these set of obligations concerns any kind of AI system that interacts or is intended to interact with natural persons. So those 8 categories are listed on this slide. If we have time, I'm happy to take questions and to respond and discuss any of the categories, but this is essentially, I think, what is the key. Actually, the key takeaways are twofold or threefold. Risk management protocols would need to be set up in a way that risk management is an iterative, continuous process. Data governance would be extremely important in order to ensure fair outcomes and output of the system. Quality management would need to be embedded, built into the system in order, again, to be running throughout the life cycle of the system and to be demonstrable, can be proven, can be demonstrated, and including via technical documentation. Quality management would be ensured based on the adoption by the AI providers of specific standards that already exist with respect to quality management, but also with some of the systems, quality management would actually be audited by ex-ante external conformity assessment entities. Users of high-risk AI systems would need to, most probably would likely need to conduct fundamental rights impact assessment under the proposed amendments by the European Parliament, which I think is a significant additional obligation for the entire ecosystem, and would be changing the game significantly. And any AI system that interacts or is intended to interact with natural persons would need to be set up in a way that it lets the users, the natural persons, know that they interact with an AI system, which would also play out in various ways throughout the process of design, development, deployment, and use. Next slide, please.
Well, if we talk about obligations, according to the UK white paper, no statutory obligations will be posed on the actors in the AI value chain, except for the fact that they will have to embed the principles which will be issued by the government and on which the regulators will provide guidance in their products and services. And this is the level of compliance that will be required to businesses following the requirements that will be afterwards set out by the regulators in their specific remits, depending on the context. And of course, the bottom line would also be conducting risk assessment and manage the risks associated with the different type of applications in the specific context arising from the user and development and user of the AI systems. In this regard, it is suggested by the white paper that the businesses undertake impact assessment audits and performance testing as part of assurance techniques that will be made available also centrally by the new central functions in the future. And of course, technical standards will support the implementation of risk management and mitigation practices when developing and building those AI systems. So I agree with on the fact that we are running out of time, and maybe it would be better if we start taking questions on what we have displayed so far in order to wrap up easily afterwards. I don't know whether Margarita
it will also make sense to go to the presentation kind of wrap up slides, which has the overall picture to just so that we can have like a template to for our audience to see while we do the wrap up. So I wanted first to express my thanks, and really, Valentina Desislava, thank you so much for your very comprehensive presentation here. I just wanted to make sure that we also have some overall an overall kind of a bird's eye view, if you want, to some differences and similarities we have there for the audience members that are either not based in the EU or the UK, or we may also have some audience members that are in a broader community of stakeholders, or they are interested in this area and do not have a legal background. So it does make sense to do this, I think. So I just wanted to emphasize that we have two separate jurisdictions that now have their own separate approaches. Now, does this mean that they will indeed have very different approaches? Well, that is more debatable. First of all, as Valentina Desislava have mentioned, both regulators want to emphasize the importance of societal values and principles that are very important for our democracies and fundamental rights. They may do so in a different language, but still principles are in the heart of both instruments. So indeed, as a broad distinction, we may say in this presentation, and you also may see this in other discussions, that the EU has a risk-based approach and the UK is kind of a more principle-based approach. But as Desislava mentioned in the presentation, principles also guided the EU's approach in AI regulation already with the beginning of the AI high-level expert group. We also see that risk, again, plays a central role. I mean, in the EU's frameworks, we have the whole architecture of the instrument of the AI Act is based on the risk taxonomy, while on the UK white paper, we see that the UK regulator, the UK government instructs the UK regulators to actually prioritize a risk identification in their own work. Because this is something I want to clarify. In the UK, there is a prioritization of the so-called sectoral approach. So what happens there is that we have specific regulators that oversee particular sectors of economy. So, for example, we have the ICO or we have the CMA for different areas. So, for example, the CMA in particular oversees competition and consumer law issues. So essentially, the government instructs sectoral regulators to draft their own rules that are particularly attuned to their own sector. Of course, while the EU, on the other hand, is introducing an instrument, a legislative instrument that is horizontal, that is going to apply across sectors of the economy. So in a sense, this is one main difference that if you want, the horizontality and then sectorality. But again, on second thoughts, there are some blind spots there too. Why? Because the UK government wants the sectoral regulators to collaborate, to come together and draft common cross-sectoral principles that will apply to all sectors of the UK economy. So it is very likely that in the coming months, the UK regulators will have to draw on the EU horizontal initiatives to have, in the end, a common framework of cross-sectoral principles. We haven't really talked about standards in this presentation, and I'm sure standardization is on its own right an issue, a theme for another webinar on its own, but standardization is going to be very, very important in both settings. This is for practical reasons. Standardization bodies have already started working on the standards that are going to help with the operationalization of the EU AI Act requirements, and they will enable companies to comply on the ground with these requirements, which is of course very important because most companies will provide their services in both contexts and of course to other non-Europe-based areas too. Both contexts are of course under development, so we don't really have finalized solutions yet. So this presentation wanted to give you the overall state of the situation in both settings, but we await for further developments. The trialogue may change a lot of things in the EU's front, because usually in the trialogue there are discussions that try to confront proposals from the parliament. So we may have eventually the other choices in the final draft. So some of the Parliament's amendments, some of the Parliament's proposals may not be able to survive in the end in the final text. And in the UK, we are still earlier than that. We are still in the stage of the regulators trying to come together to draft a framework on cross-sectoral principles. So we are going to follow these developments closely in the coming months. We would very much welcome questions from the audience. If someone wants to ask a question, they can write their question on the chat. I cannot see any questions until now. I also wanted to make another point before. We also have two. Great. We have two questions indeed. Before going to these two questions, I also wanted to add a final thing, an observation I had with on the presentations. I mean, both Valentina and Slava talked about risks. It is very important, in my view, as a reflection on the presentation, to establish evaluation metrics, and this is in my view, the most important point going forward in terms of what we need to do is to establish more robust evaluation metrics for these instances of risk materialization. So how we can measure instances of risk of cases where risk materializes. This is not only this includes, of course, discrimination, but also misinformation, and especially in the context of generative AI tools. So this is all the more important. So we have two questions from Attila Kasap. The first one is, there are existing rules that could be applied to AI-applied products and services, such as motor vehicles and unmanned aerial vehicles, to ensure safe and secure operation. How can we align the EU AI Act with these rules? This is the first question. And the second question is, can the EU AI Act be applied to AI systems such as ChatGPT that do not have a specific single use? Do you want, this is Slava or Valentina, do you want to take on the first or the second question? Of course, I can, after your response, I can also add a few things.
Yeah, sure. Well, the AI Act, the EU AI Act, is meant to be a legislative framework providing rules precisely for all the AI systems that could be per se or a component of other products, and therefore also need to be read, to be interpreted, and to be applied along with other legislation, as Desislava said before. And I'm not an expert in matter of unmanned aerial vehicles, but for sure that category of products are regulated by other set of legislative acts, and may likely fall within one of the annexes to the AI Act, which would trigger the qualification of the potential AI systems applied to those products as high risk AI systems. And as regards the second question, yes, possibly I wasn't clear before, but there's the EU AI Act provides for a new category of AI systems, the general purpose AI, and also for foundation models, which is a subset of general purpose AI, and ChatGPT would fall within this category of general purpose AI. And indeed, there have been discussions in the last days on the fact that on the fact that ChatGPT, the OpenAI, may leave Europe in case the EU AI Act becomes too much prescriptive with regard to those categories of AI. So this is my answer to the two questions and my take on them.
Mm-hmm. And if it is, this is Slava, if you don't have to add anything, may I offer some clarifications on these too? I think this would be helpful. So to clarify, indeed, the EU has various rules on motor vehicles, unmanned area vehicles, aerial vehicles, toys, and machinery, and all the other stuff. So these rules are generally considered to be part of the so-called NLF framework. So mainly these rules are applied on the ground through standards. And these rules regarding all these technical areas of society, if you want, these rules are safety rules mainly. So safety is at the heart of these rules. We want all these technical tools and machinery and vehicles to be safe. So while the EU AI Act was inspired by these safety frameworks, if you want, these safety rules, it goes beyond this. It wants to adopt a broader scope because it wants to also bring fundamental rights in the heart of the rules. So it indeed is inspired by those frameworks, like the frameworks regulating machinery and toys and vehicles, but also wants to bring at the heart of the regulation fundamental rights, because as Valentina Netsislava mentioned in the presentation, we have risks that threaten fundamental rights. They may be discriminatory. They may spread misinformation. They may be a threat to democracy. They may undermine markets or the provision of education and so on, while mainly safety is the heart of the other frameworks. So this is one main distinction to be drawn here. So the EU AI Act, it's important to remember that it goes beyond this. And to just add a kind of tricky point here, there is a debate going on whether standardization, which traditionally kind of ensure that we will have safe technology, how standardization bodies can have actually the expertise to create now standards regarding fundamental rights, but I will leave this open. And regarding the second question, I wanted to just clarify that indeed, as just Valentina said, there are discussions to create generative AI specific rules, but we don't know much yet about this because it will be heavily negotiated in the trialogue. So in the coming months, where the Parliament, the Commission, and the Council will be negotiating these rules. Now I see we have one more question from the audience, and this is one of my kind of favorites, because it says we see that pro-innovation is a catchy phrase on the white paper, and how could we potentially balance pro-innovation with the fundamental rights? This is a very difficult question to answer, and indeed I would say that there are concerning elements in the white paper, because there are points where the UK government says it is important for consumers or for the public to realize that AI advantages outweigh the risks. So there are certain phrases that are particularly problematic. Indeed, oftentimes there are dilemmas and choices to be made, but of course we should be as legal professionals, we should be very alert in the coming period, because we really don't want our legal rights to be sacrificed in the name of kind of catchy or modern or kind of the buzzword of innovation can be misinterpreted many times and can lead to disastrous solutions and journeys in the end. This is what I would say with regard to this more policy-oriented question.
To add to the complexity, I would say, how do you balance innovation with protection of fundamental rights and with legal certainty? Because legal certainty is something that also benefits business significantly, and business typically expect more than anything else legal certainty. So if a legislator doesn't set up a predictable framework, how any kind of innovative approach would actually pay back if businesses wouldn't know which way they need to go in the longer run, especially for heavily investment intensive technologies like AI. So I think the policy choices are extremely challenging, and maybe we'll see in the next couple of years which one has been the wiser or the wisest one. But I think those that we are talking about nowadays, each one is inspired by its own national and legal traditions, and more probably also idea of which jurisdiction could offer, could gain some kind of a regulatory competitive advantage vis-a-vis the other.
It is slightly ironic that with generative AI, that the UK wanted to actually put their eggs mainly on AI and the creative industries, and with now DALL-E and Midjourney, these two communities, AI and the creative industries, are fighting with one another. So it would be interesting to see how the UK will deal with this issue. Okay, thank you so much for this presentation. Thank you, Desislava. Thank you, Valentina. It's been a wonderful afternoon. Thank you very much to our audience. Thank you for joining us today. And we really hope you will join us in the next webinar. Thanks again, everyone. I wish you have a great evening or a great rest of your day.
Thank you, everyone.
Thank you.
Bye.
Bye.